Hello, everybody. This is Bill Kroger. I'm president of the Houston Bar Association. Thank you for joining this webinar. Um, we are obviously living in very unusual times, historic times, given all the things that have taken place over the last several months. And one of the things that for lawyers that we're particularly interested in is the impact that the coronavirus has had on our judicial system, particularly our local court system. The people on this call are mostly trial lawyers, and we have a deep interest in learning about how we are going to be restarting trials and what that experience is going to be like so that we understand that and can communicate it to our clients. And with that in mind, we thought on behalf of the HBA, we would present this webinar from three of our judicial leaders who are help leading that effort of restarting jury trials safely in the Harris County courts, as well as other types of proceedings, and have given a lot of thought and attention to those issues. So with us today, we have Judge Rabia Collier. She was elected as judge of the 113th District Court in 2018. She is currently the co-chair of the COVID Response Judicial Task Force for Harris County, which focuses on reopening courts to in-person proceedings and jury trials. Second, we have Judge Kristen Hawkins here. She has presided over the 11th District Court since 2016. She currently chairs the Board of District Judges Jury Committee and co-chairs the COVID Response Judicial Task Force on reopening courts to in-person proceedings and jury trials. We also have with us today Judge Robert Schaefer. He is the judge of the 152nd District Court and has been in that position since 2009. He is also the Harris County Local Administrative District Judge. That position has statutory duties, but speaks and acts on behalf of all of the district courts. He has also been involved in getting the courthouse complex back to normal, first since when Harvey hit us in 2017, and now helping address the issues with the COVID-19 pandemic. Thank you all three for being here today and spending time with us. Judge Schaefer, let's kick it off with you and kind of maybe you could share with us an overview on how the facilities are doing and kind of where we are.
Sure. I thank you, Bill, for having us on this webinar today. It's an honor to be here, and I'm glad to have an opportunity to visit with your members. We are coming to the end of the rebuild period of Harvey, and now we're also right in the middle of this COVID-19 pandemic. So at the present time, all the courthouses are operational, but they're operational on a limited basis. And that's because we have the social distancing requirements, we have the requirements relating to the number of people that can come into courtrooms and be in a specific room. And so most of the judges right now are operating remotely to the greatest extent possible. It's kind of hard to have hearings with lots of people in it because of these restrictions. Second, we're not doing jury trials right now. Juries have been suspended until at least the end of June. The most recent Supreme Court order relating to COVID-19 extended that into July, but under certain circumstances, if you have an interesting, unique, or special situation, you can approach the administrative judge and the regional presiding judge, who is Susan Brown, about possibly having a jury trial. That's pursuant to the latest Supreme Court order. But we're still under these restrictions for a while. All the judges, except for the criminal district judges, are now back using their courtrooms, but with the restrictions that I've just mentioned to you. That's kind of a really abbreviated version of that, but if you have any more detailed questions about that, Bill, I'm happy to answer.
Great. Judge Collier and Judge Hawkins, maybe share with us sort of the big picture on how kind of what's going on in your courts and what kind of proceedings you've been having over the last, say, month or so.
Well, in the 11th court, we are having phone dockets every Monday, and they're pretty much like our regular Monday morning dockets. Everybody who's on the 9 o'clock docket calls in the same conference line and gets to listen to all the motions that go before them. If you have more than, 5 or 6 people involved in your case, then I'll probably put you on a Zoom call. Or if you're going to take longer than you would just on a regular motion docket, longer than your typical motion to compel, longer than your typical motion for continuance or summary judgment argument, then we would put you on a different call like I would any other time. And we do have Zoom hearings available. We have previously, the 11th court has not had a submission docket, but we do have a submission docket now. If I do look at your motions and think that I want to hear some argument, though, I may set you for a phone hearing or a Zoom hearing. We do not have any in-person hearings right now. I do not intend to have any in-person hearings anytime soon, unless it is an essential hearing that we actually need somebody down at the courthouse. So that's where we are in the 11th court.
In the 113th, we are also having Zoom hearings, telephone hearings where they're appropriate. We are limiting the amount of in-person hearings pursuant to the Texas Supreme Court and OC8 guidelines. And as we talk about kind of this entire topic, I think it's important to have a framework in mind. And I think it's important for the members to understand that the judiciary recognizes and appreciates the economic realities of our, not only for you all, your practices, but your clients, our neighbors, our community, as well as public safety, making sure that people feel safe in proceeding, and then ultimately making sure that constitutional rights are upheld and that we keep our justice system going. So I think that's an important framework to work off of, knowing that that's how we're developing the procedures of reopening the courts during this COVID period.
If I have an important motion pending before the court and I want a hearing, who makes the decision about whether it's a telephonic hearing or a Zoom hearing? Is the Zoom hearing something I need to request? Do I do it orally? Do both sides have to agree? How does that in practicality work?
Well, if you want a hearing, all you have to do is ask for it in the 152nd. You can get a telephone hearing on just about any motion. You can get a Zoom hearing on just about any motion. You really have to ask for it. If you want a Zoom hearing, then you contact my coordinator, Nalani Calico, and she'll set it up for you. I've gotten emails from her today that indicated I have 4 Zoom hearings set up for this coming Friday. And one of them is going to be an hour to 2 hours long. So in my court, it's really up to you how you want to do it, but you have to ask for it. We can't read your minds. We can't anticipate what you want. Just call the clerk and she'll either set up the telephonic hearing or she'll forward the call to Nalani, who will set up the Zoom hearing.
That's similar in the 11th. We tend to default to just a normal hearing on our normal docket, but if it is a more lengthy motion and you have a PowerPoint presentation, you want to maybe share your screen, or like you would want to hand to me if you were in the courthouse, then yeah, definitely ask for a Zoom hearing. We'll set it up. It's just like Judge Schaefer said, my court coordinator is going to send you a Zoom link and we'll set it up. It will have to be at a different time, not the 9, 10, or 11 o'clock Monday morning docket, but that's like we would for any other larger hearing, any other more lengthy hearing. We would set it up at a different time so that everybody had plenty of time to be heard and the court could consider it fully and not be rushed with other motions.
So for the 113th, we default to Zoom. So we'll set you up for a Zoom hearing. We really rely on the lawyers to identify any issues that any party or client may have in participating in a Zoom hearing. For example, if there is and we all know that there's a digital divide in our community. And so if we're representing someone that doesn't have the necessary hardware, software, equipment, or even whether they may not be best suited for a Zoom hearing, maybe they have a hearing impairment, we as the court really rely on the lawyers to bring that to the court's attention, mention it to the staff, and then we set up a telephone conference or a telephone hearing in replacement of the Zoom hearing when a Zoom hearing is just not practical for that particular case.
Are all the courts in Harris County using Zoom, or or does each court have the flexibility to use whatever platform they would like to use?
I think they're probably mostly using Zoom because the OCA in Austin uh, has made it available for whoever wants it. They purchased a lot of licenses, and the district court administrator here in Harris County did the same thing. We've got our own license. We have our own ability to broadcast. We don't use YouTube, and so yeah, it's mainly Zoom. But I think other folks have different platforms they're using. Just depends on who sets it up. But if it's set up by the courts, it's probably set up on Zoom.
Yeah. There are some functions on Zoom, for example, the record function. Um, are lawyers allowed to record the Zoom hearings?
No. I have a standing order in my court. I think everybody pretty much has a standing order, but there's local rules as well that address the recording of any court proceeding. And it would be a violation of those rules to have an unauthorized recording of the court proceedings. Many times you will see another warning on our screens that say do not record. That's just a reminder, but there are standing rules in place that prevent recordings of court proceedings.
If there's multiple lawyers on my team, or if several of my clients, for example, want to attend the Zoom hearing, is that allowed? Do I have to ask for permission for that?
That is allowed, but I would recommend that for anyone that's not really participating actively in the hearing, it may be better for those persons to have the public link access so that there may not be any additional issues that may come up out of the Zoom hearing. And what I mean by that is sometimes courts set up their Zoom hearings where there's a waiting room. And so if a client logs off by accident or loses some type of signal, and then they try coming back into the hearing, there may be a lag time for them to get out of the waiting room and into the main session. So for clients and associates that are perhaps not actively participating, maybe learning from a senior attorney, it's best to go ahead and give that public access link because they can continue to view it and not necessarily be within the Zoom meeting.
Bill, the public access is the most important part about this. You know, our state constitution says our courts are open for people to participate and to observe to the greatest extent possible. And so that was a primary focus for us when we were trying to set up these electronic links to get you into the system. We wanted to make sure that if someone wanted to participate, if somebody wanted to observe, they were able to do so we could be, like I said, to the greatest extent possible, compliant with Article 1, Section 13 of our Texas Constitution.
What if I have a evidentiary hearing and I need to put on testimony? Do we do that through Zoom also, or how does that work?
I have had a bench trial through Zoom, and I have had a temporary injunction hearing through Zoom. So I have received testimony, oral testimony, and now as far as documents are concerned, the way we've handled that to date in the 11th is those exhibits have been filed before the hearing so that everybody had a chance to see the documents and review them. And I ask that lawyers do what I would ask them to do if they come to court. Exchange your exhibits and be prepared to make any agreements that you can make on the exhibits before we get the hearing started, because I will ask you that just like I would in court, if we have any agreements on the exhibits or not. And be sure that you are prepared to discuss them. Sometimes email works, but if they are voluminous, I know that other courts have used Dropbox and some other, online services to allow for the exchange of exhibits. That's how I've handled it, though, in the 11th.
I've also had a 2-day evidentiary hearing with witnesses appearing remotely from their separate locations and coming in. I've had experts come in and testify through Zoom hearings, and it's worked really well, actually. And I've gotten really good feedback from the lawyers and the witnesses in just the efficiency of it alone.
I haven't had any any evidentiary hearings so far in the last couple of months, but to the best of my knowledge, people haven't asked for it. If they did, we'd set it up. And in spite of the fact that I'm an old guy, I could figure out how to do that. I have two very capable women on each side of me on this screen who could show me if I needed any guidance. And I wouldn't be bashful about asking either one of them, by the way.
If it's an evidentiary hearing, maybe it's a trial, maybe it's an injunction, or some sort of emergency hearing, do both sides have to agree to do it through Zoom, or have parties made objections to having a Zoom hearing? And if so, how have those objections been handled?
Under the current guidelines from the Supreme Court and the OCA, you do not have to consent. The court can tell you that you are going to have a remote hearing because of the COVID-19 pandemic and because of the current rules from the emergency orders from the Supreme Court and the guidelines from the OCA restricting in-person hearings. We do not need the consent of all parties. That could change the further we go, depending on what types of hearings they are. But we will, even after July, be strongly encouraged by the Supreme Court and thus by your local courts to conduct as many remote hearings as possible. So if it is feasible, then we are going to suggest that you do some sort of remote hearing. And Judge Collier, you may want to talk to this. We were in another call earlier today in which we talked about self-represented litigants and their access to the court. And there's another member of our task force that has been working very hard on that. Judge Collier, would you like to fill everybody in on what's going on there?
So it's very exciting. Judge Barbara Stalder has been working very hard in making sure that we have access to the courts even during this pandemic. And she's partnered up with the local libraries to facilitate an area within the library to allow members of the community to come in and be able to access their Zoom hearings. Oftentimes, we know that even if you have access to the technology, the laptop, and you have internet access, sometimes some of our clients or certain people just don't know how to manage the Zoom process in getting on the hearing and being able to participate. So this is just one more way for us to make sure that we bridge not only the digital divide, but also the technology gap that there may be in, or the hesitancy of the public in participating in Zoom hearings. So she's worked out, and we're working through the details to make sure everything is smooth. But so far, we have a total of 8 locations across Harris County at the public libraries that will facilitate these Zoom rooms where the public could go and access their hearings there.
Oh, that's great. How would you get information on where those facilities are located?
So as soon as we have everything nailed down, as soon as the equipment is done, and as soon as we do have the locations. I think Judge Stalder has at least a preliminary spot on locations. But once we have the final equipment installed, we will be, making sure that information is sent to you, Bill, and out to all the members of the HBA and to all the other affiliate bar organizations as well, because we want to make sure that as many people have access to this information as possible. And I think Judge Schaefer would tell you too that, with the restrictions on the number of people that can come into the courthouse and wanting to limit just overall foot traffic, this is possibly another way that we could help alleviate that, but still give people full access to the courthouse. I'm
going to come back to Judge Schaefer and get an update on kind of the facilities and some of the practical questions that lawyers have asked, for example, whether they're going to have to wear a mask if they go to trial. But let me first have you get out your crystal ball. Do you think that the experience of using this technology in the courtroom will carry over even after the pandemic has gone away? For example, do you think Zoom hearings will be a regular part of judicial life going forward?
So Judge Hawkins and Judge Schaefer and I have been participating on a ton of webinars that are being hosted across the country with judges from all different states. And the theme, the consistent theme has been that this pandemic has really pushed the legal community to progress in how we introduce and use technology to make the legal process more efficient. And so I think the consensus is that we will be using this technology, Zoom hearings, remote appearances more frequently, and even after the pandemic.
I agree with that completely. I think this has changed what we've done and how we do it. I've always been in favor of you using a telephone if you're in Austin or some other locale, so that you don't have to spend 3 or 4 hours on the road coming and 3 or 4 hours on the road going back. Save that money for your client. So I think absolutely it will be something that we look forward to in the future. Will it replace the oral hearing? I doubt it seriously, because Bill, lawyers like you are going to want to get FaceTime in the courtroom to advocate on behalf of your clients. There's one judge, and I'm not going to out this person, but who hates this with a passion. He wants to get as far away from Zoom as he possibly can so that the lawyers can be live and in person. And that's fine for him. But for those of us who want to do it somewhat differently, that option is now available. And I think we're going to be using it frequently from here on out.
And I think one of the things you may see too, and they are really, I think, making strides on this, especially in the criminal courts and possibly some of the family courts, is kind of a combination. If you go over to the criminal courts right now, they have a big TV in the courtroom that everybody can see. They've got a judge sitting on the bench, and they may have a defendant who has been brought over from the jail. But you have the lawyers on the screen, the prosecutors on the screen, and you have other court staff appearing remotely, but are able to observe all the proceedings in the courtroom. So will it look exactly like that when we're done? I don't know that it will, but it could be some hybrid of the lawyer zooming in from Austin and there being a local lawyer or some other hybrid. But yeah, I do think that integrating this technology into the court system is something that will go forward.
Thank you. So many of the lawyers who are listening to this webinar will have fall settings. What do you think is the expectation of what jury trials will look like this fall? Will we actually have them?
Yes. I don't know how many, but yes, we will have jury trials this fall. We are in talks right now with the county for securing a larger location to assemble juries, and to not only assemble the juries at that larger location, but also to conduct voir dire there. And then once voir dire is completed, having the jury appear the next day at the courthouse. Right now, we are looking at NRG Arena because there is a lot of space. There's a lot of parking there, and it is an easy space to get to and to assemble a large number of people. But yes, we are actively working on that. And in fact, we are going to call grand juries in July. And so we will have some grand juries being impaneled in July.
Bill, the issue that we've had to deal with is space. With the county jury assembly building being out of commission, at least until around February of next year. We've been dealing with the county admin building in the basement, which could hold around 230, 240 people on a good day. With this COVID-19 pandemic that we've had to deal with, that has shrunk that space down to about 40 or 50 people. So we've had to find a place where we could assemble the folks. Then we have to find a place where we can conduct voir dire. And after we conduct voir dire, we have to find a place where we can conduct the trial. I don't think anybody's going to really think it's possible to put the jurors in the jury box, seated shoulder to shoulder during a trial, because that's going to scare people off. So we're thinking that it will probably be the gallery where the jury sits as opposed to in the jury box. Well, then we have to find a place for jury deliberations to take place. And so these issues are really big issues towards doing jury trials in the future. And the first one is one that Judge Hawkins is working very diligently on to try to get us set up somewhere where we can call the folks and conduct the voir dires. And we hope to have that firmed up to a great extent in the next week or so.
Is the expectation that the voir dires in front of the jury panels would be similar to what we've done in the past in terms of similar numbers of people where they all listen to the lawyers at the same time and raise hands or answer questions? Or is it going to be, would you anticipate a different type of voir dire process?
Well, I think that there's going to be variations based on which court you're in. And I think understanding that it may look very different is probably the best place to start from. Making sure that we are keeping the public safe. One of the things that we've implemented are some pre-screening questions with the actual jury summons, so that we can get a realistic gauge of how many folks are going to respond to the jury summons, and a realistic gauge of whether or not that particular panel will get busted, and the realistic nature of all the issues that are going on right now, whether that's someone being ill or taking care of someone that's ill, financial issues that they may be going through, as well as childcare issues. I know that the governor has loosened up the restrictions on childcare, daycares, but those are still concerns that I think that the lawyers will need to discuss during that voir dire process. And so what we wanted to do is make sure we implement some type of pre-screening so we can get an idea of how many folks are we really dealing with, and then get a realistic gauge of what is the safest place to have a voir dire. Because as of right now, the fire marshals have limited the number of people that can actually be in our courtrooms. And so if a civil district courtroom can only hold 25 people, how would we have a voir dire when we normally call about 48 to 50 people? And that doesn't even include our staff or the judge or anyone else that may be participating, like the lawyers. So the actual location has to change. And then I think from judge to judge, see a difference in how much participation that the lawyers will have, whether that's based on a questionnaire, whether that's more of a judicial voir dire, whether that's a voir dire that's from a podium at a safe distance. But these are all things that we've been talking about and making sure that ultimately when we start the voir dire process, it's in a safe way.
Has there been any analysis or thinking about whether if we do, if we start up juries and jury panels, whether the composition of the juries will be different because of the pandemic? Will the people who show up for jury service be different than what we would have seen a year ago?
That's something we're very we're very concerned about that. We don't know right now, A, how many people are going to respond to the jury summons, and B, who is going to respond to the jury summons. As you know, this pandemic has hit different populations very differently and dramatically. So we are, as we summon for grand jury, that is something we are going to be very aware of, and that we're going to be looking at to see what does our panel look like when this next jury summons goes out, and who is responding to jury service. It's something that we're going to be watching the whole time, quite frankly. This is something that, we are concerned about, and we want to make sure that our jury panels are representative of our community, because that's how we believe that people get a jury of their peers and have a fair trial down here in Harris County.
I will add, Bill, one quick thing about voir dire. We've been talking about face masks or face coverings, and the ability for the lawyers to be able to gauge the facial expressions of the panel. And so there has been a lot of talk about potentially having face shields, which would be a clear separation to hopefully contain the droplets and provide safety, but also give the lawyers the ability to read expressions and the nonverbal communication that we so heavily rely on.
The randomness of the jury panel is what's really important, and something that I think Judge Hawkins was referring to. There are certain demographics and communities that have been hit harder. So if you're over 65 and you get a jury summons, are you going to show up or not? If you're concerned about whether or not the safeguards are being utilized down at the courthouse or wherever it is that we're going, will you show up? Are there other demographics, other communities that have been hit hard by this? They'll say, well, this is too dangerous right now. I'm not coming. And if that happens, does it impact the randomness of our jury panels, which is a prime concern of ours?
Do you anticipate that everybody working in the court, whether it's a juror or the lawyers or the court reporters, the bailiffs, everybody's going to be wearing face shields?
In the courtroom, the judges are most likely going to require face coverings during any court proceedings. If you are down for an in-person hearing, then be prepared to be required to wear a face covering of some sort. We have some limited supplies here that if you do not have one, we would be able to provide one, but we would request that you bring your own because you will be required when you come into the courtroom to have one.
It's going to be necessary that you take precautions to keep the potential for spreading the virus. So in the operational plan and in the Supreme Court advisories and OCA advisories, facial coverings, social distancing, and just staying away from one another and not projecting. And so the facial coverings is going to be part of it. It has to be part of it. And what Judge Collier talked about a minute ago about the facial coverings is a really big concern for anyone who works in the courtroom. The judge, the jury, the practitioners, you've got to be able to see what the facial expressions are of the folks that are testifying, the folks that are being interviewed during the voir dire process. That has a lot to do with judging the credibility of somebody. So we have to find a way. And I think the face shields that Judge Collier was just talking about is probably a lot better than a mask. And so we'll probably be implementing something along that line.
And also, we are putting up some plexiglass shields in our courtrooms right now. So the court reporter is going to be behind plexiglass. The witness is going to be behind plexiglass. The clerks, the bailiff, they are all behind plexiglass. So be prepared when you come in. The courtroom's going to look a little different. You'll still be able to see everybody, but there will be something between you. There will be a physical barrier between you and the court staff.
But even if the jurors and the judge and the witnesses are protected by plexiglass, your expectation is still that the lawyers will wear some sort of mask or face covering?
Yes. We don't want the spread among the lawyers or among the parties or among anyone else in the courthouse. We would like to limit the spread as much as possible. And so we're going to take as many precautions as we can to keep everybody down here safe, because we know that nothing is 100%. And the more protections we can put in place, the better off we will be, hopefully.
One of the things I noticed when I read, there's an operating plan that's on the, I think it's on the district clerk's website, or maybe it's on the district court's website. But there seemed to be a preference for cloth face coverings as opposed to the paper masks that we've seen. Is that the case? Is there a preference for, if lawyers come into the court, for the type of covering they should have?
I have to take partial credit for that since my signature is at the end of that document. This document was a template that the Supreme Court provided to us. And I think that particular clause is part of the template. I don't necessarily, I think that a cloth covering is preferable to a medical covering, is preferable to a face shield, or is preferable to a full body suit. I don't really think that matters as much as we want to ensure that we're limiting the projection or the potential projection to the greatest extent we possibly can. Let's
talk about the facilities themselves. not, you know, how do we make sure that the courtrooms are clean? How do we make sure people move up and down in the elevators safely? How is that going to be handled?
Well, that's an important aspect of this whole thing as well. So when you come in the come in the courthouse rather, the first thing you're going to face is someone there who's taking your temperature with a touchless thermometer. You'll also be asked several questions about whether you've had a cough or a sneezing or a temperature, or you felt good or you felt bad, or any number of things. There might even be a question about whether you've traveled to some place that's had high instances of COVID-19. I think we've got a series of questions that have been established, and you'll face those when you come in the door. From there, you're going to have to go to the elevators. And the elevators right now are still limited to 2 folks or 1 family unit. So 2 people can get on, or 1 family unit. We're hopeful that with the help of the public health folks, we can increase that a little bit so that we can move more people through the courthouse. That's going to be really important over in the criminal courthouse, where you've got more people coming in on a daily basis. And then we're going to try to make sure that when they come in the courtroom, that we do limit the number of people in the courtroom to 25 people, and they're socially distancing the way they're supposed to do that. And then we have to worry about what's going on in the halls, and to ensure that folks are not falling all over each other in the hallways like we're used to in some places like the criminal courthouse. So yeah, there's going to be people who are going to be working to try and make sure that people comply with these requirements.
Is that one reason why even when we start up jury trials in the fall, we'll still be doing a lot of things remotely just to reduce the number of people that have to come into the courthouse every day?
Yes.
Do you anticipate that, for example, there will be a line to get on the elevator, or is that something that we're trying to?
We sure hope not, but yes, probably. But keep in mind, we're still, like you just said a second ago, we're still going to try to work remotely to the greatest extent possible. So just because Judge Collier and Judge Hawkins and I have now the ability to go back in our courtrooms to conduct proceedings doesn't mean that we're going to just open the door and say, come on down, folks, and let's have some fun. It's not going to happen that way, because we still have to make sure that the buildings don't become inundated with people.
The other thing we're going to do is, we'll look at staggering dockets so that we don't have everybody coming down for one court or another all at one time. So staggered dockets is something that you should look for if we're going to have in-person proceedings. And that's another reason when we are looking at a space for juries to gather that, we need a large enough space so that we can stagger them so that they can come in, but once they're in, that they have enough space. These are all things that we want to look at. And one of our preferences when we were looking for a place to gather jurors is that it's all on one floor and that we don't have to have elevators, because with that many people coming down, the lines with an elevator would be very long, and it would be very, very time consuming to get everybody up to another floor if we had to conduct voir dire up here in the courthouse.
Okay. Do you think even when we start up the jury trials in the fall, injunction hearings and emergency hearings, those will still be done on Zoom?
Yes.
Yeah. Okay. What do you think is the timeline for when we kind of, not just when we're doing like 1 or 2 experimental cases or doing, but when do you think we'll be doing on a regular basis jury trials at the court in the fall? Do you think it's in August, or you think it's going to be later in the year?
I suspect it'll be a little bit later. One of the things we haven't touched on yet is the survey that the district court judges put out. Yes. And the bar does not want to come down any sooner than the fall for jury trials. But not only that, we're not moved into our jury assembly space yet. So we have to get it there. We have to see who's responding to our jury summons. We have to figure out how it's working down there. And so it's going to be slow at first. And then the second thing that's going to happen once we start having some jury trials is there may be a preference for criminal cases over some civil cases, because there is a jail population that needs to be addressed. And the way that that gets addressed is by having trials. And so a lot of criminal cases may come first, like Harvey. You may recall after Harvey, the civil courts refrained from having trials for a few months longer than the criminal courts did, because they needed to have those trials because there are a lot of constitutional due process issues that come into play. And then there's also the jail population that gets addressed by having trials. So those are going to be our concerns as we look forward to having regular jury trials. And as we work out all the kinks that are going to come with this, those are the issues that we're going to be facing. And so we will have grand juries in July, maybe 1 or 2 experimental trials in July with the permission of the Supreme Court and with the permission of all the parties. But then after that, we will start most likely having some criminal court trials in August. So I would not anticipate having regular jury trials until later in the year, September, October.
Let's talk about the survey for a minute. We've distributed it out to our members. I think a lot of the people on this webinar have seen the survey. What was the purpose of it, and how did it inform your thinking about the trials and proceedings in the fall?
Well, we really wanted to know what the bar was thinking. We were dealing with a lot of Supreme Court orders and a lot of directions from OCA, and we knew what we were thinking here, but we hadn't gotten a chance to interact with the bar and talk to them about their thoughts. And we knew what we were thinking as far as guidelines that we were going to potentially put in place when we come back to in-person proceedings. And we wanted to see what the bar's opinion was on that. And what we found was that they were thinking the same things we were. And we were thrilled to see that they want the same kind of precautions in place that we were already planning on putting in place. So that's the preliminary thoughts on the survey. But why we did it is because we really were genuinely curious and wanting to hear from the Harris County Bar. Judge Collier, I know that you worked a lot with me on that survey. We developed those questions over several weeks. So Judge Collier, what were your thoughts when we got those results back?
I was pleasantly surprised, and I think the takeaway was that, everything that we were already had in place. It's kind of in line with how the bar was thinking. But really, I think the insight from our perspective was we understood that there was a lot of social, economic, emotional issues that were just across the board, because there was one question in particular that was asking about if the lawyers had issues. I mean, would they feel comfortable raising it to the court, and how would they feel comfortable raising it to the court? So the judiciary really appreciates and recognizes the situation that we're in. And it's not just limited to one particular industry. It's people across the board that's being affected by the pandemic. And that's why we really wanted to seek insight from the bar to make sure that they knew that although it is mandatory when we request a hearing or we set a hearing, that your appearance is necessary to be there, to be in court and be on time and have your responsive pleadings on file and be a great advocate for your client. But at the same time, we understand that there's a pandemic. And so we wanted to open that dialogue between the bar and the judiciary in this very unsettling and very new grounds.
One other thing that I noticed in the survey results, we did ask to break it down by practice area. So we asked for what's your main practice area? Is it civil? Is it criminal? Is it family? Is it juvenile, probate? And then we went a little bit further and we said, are you civil defense? Are you civil plaintiff? Are you criminal prosecution? Are you criminal defense? And there was no difference in the types of responses we got. This is not a plaintiff or defense issue. It is not a prosecution or defense issue. It is not a criminal or civil or family issue. These are, this is how the bar is feeling about a lot of these things. And that was something that I was pleased to see, that it was across the board, that everybody feels the same way. Judge Schaefer, what did you think?
Yeah, it was really impressive to me. One, how many people responded. We had over 3,100 people respond to this, and two, I was really surprised, like the others have said, at how similar the views were from practice area to practice area. You would think that the plaintiffs, the civil plaintiffs and the civil defendants, attorneys on those sides would look at things differently, and they really didn't. When we were thinking about facial coverings, it was 75% or more of the folks across the board who wanted facial coverings. And so it was really impressive to me, and surprising, as Judge Hawkins said, that some of these answers came out the way they did.
Let me close with just a open-ended question to you with a comment. When we circulated the idea for this presentation, we suggested and thought that this would be appropriate for ethics, because I can't think of any more ethical responsibility a lawyer would have than to help keep the courtroom safe. That just seems so fundamental to me. And the more that lawyers are informed about the safety procedures that y'all are considering for the courtroom, the better they'll be able to comply, and the better they'll be able to make sure the public understands that and their clients understand that. What's interesting is there's no specific rule, at least that I found in our professional ethic rules about pandemics or safety. I mean, it's just sort of, there's always been an assumption that we've never just had anything like this before. The one thing, though, that did catch my eye in looking through our ethical rules is the preamble. And it has a couple of paragraphs in there, paragraphs 5 and 6. And it talks about how a lawyer should seek improvement of the law, the administration of justice, and the quality of service rendered by the legal profession. How a lawyer should cultivate knowledge of the law beyond its use for clients, employ the knowledge and reform of the law, and work to strengthen legal education. Talks about how lawyers should be mindful of deficiencies in the administration of justice and of the fact that the poor and sometimes persons who are not poor cannot afford adequate legal assistance, and that therefore they should devote professional time and civic influence on their behalf. I was thinking about those words in light of all the things that are going on both in the last week and also the last several months. And I wondered how, if each of you might share with us your thoughts in your role as leaders of our courts and of our legal profession in Harris County about the responsibilities of lawyers in this community.
I think everybody who's involved in this process has to take a look at the big picture. And the big picture is to try and keep the community safe and to ensure that we don't spread this virus beyond what it's going to naturally do, and to the greatest extent we keep it from doing that. And so I think that is probably a primary focus for what we're doing. I know that some of our ethical rules require us to work efficiently and promptly and don't do things to waste time and things of that sort. And I know this process is slowing things down to a certain extent. But I think it has to slow things down to a certain extent, because we want to make sure that people are having their opportunity to have access to the courts and to do it fairly and efficiently. But I'll also say that the colleagues that I'm working with right now across the board are going out of their way to find ways to make this process work efficiently. You've heard these other two judges talk about what they're doing to help with juries and getting a jury assembly back in good shape. We've talked about pro se litigants and making the courts give the access to the courts to pro se litigants. And we have spent a lot of time talking about these things and trying to work these out so that we do fulfill our responsibilities to make this work for everybody involved.
You know, I'm mindful too that this does present opportunities for parties to delay or to object to a video mediation or to object to a video deposition. And some of those objections could be valid. There could be concerns about witness coaching. But I think that as a bar, we have a very creative and thoughtful bar here in Harris County. And you could find ways to solve some of those concerns. If you're concerned about who might be in the room for a deposition, get a 360 webcam. Don't use that as a reason to delay and not go forward with a deposition. You know, if you are concerned about technology access for your client who may need to participate in a hearing, then be open to a phone proceeding or to allowing them to call in to a Zoom hearing. Because while Zoom does allow us to participate by video, there's also a call-in number. So keep thinking creatively and remember that we all have an obligation to allow access to these courts that we are in and to allow everybody to participate and to participate fully as they can. And candor with the court is big. If you are on the phone and you know that somebody has dropped off, if you are on the phone and know that somebody's not there, then you need to speak up. You also need to do like you would before you come to court, exchange documents, conference in good faith. Just because you're not in the courtroom and I'm not making you go conference in the attorney ready room doesn't mean that you don't have that obligation to conference in good faith with opposing counsel. You're just going to have to do it differently. It may be a little harder, but we all have to remember that we have the same obligations and to remember that we aren't doing these precautions because we don't want you down at the courthouse. As a matter of fact, I miss lawyers. I miss having them come in live for hearings. I'm doing it though because we need to, and we need to be safe, and we need to try and keep everybody safe. You don't know if your opposing counsel has underlying health issues that might make them more at risk. So if you can be accommodating and be flexible and creative.
With everything that we're going on in the world right now, I hope that everyone is getting a new perspective, a bigger and brighter perspective, and what's important and what's not really important. And hopefully that shapes us as a legal profession and as a bar, where we rise to the occasion. And then by doing that, we become better advocates because we understand what's really at issue in the case. What really do we need to fight for in court? What are some of the compromises that we can make? What's dispositive in nature? What's not dispositive in nature, and move forward. Understanding that right now, there are so many people in our community that are hurt economically, spiritually, physically. There's so much going on that I think the bar typically in these type of situations rises to the occasion and are leaders within the community. And I think this instance is no different. We will see, and I have seen personally, lawyers that have come in the 113th and have been kinder, have worked things out a lot easier, been given the gratitude and the courtesy that's necessary, that we need to do even more so on the civil side, and I'm sure across the bar. But I think this is really an opportunity for each of us to rise to the occasion so that whatever we can do to help our community, we should do. And as judges, I think each of us on the bench have decided that if there are industries that are literally shutting down because of the economic impact of the pandemic, that we will do everything in our power to continue the justice system, not only because that's the right thing to do and because our democracy depends on it, but also because we understand that every person that relies on this system, every person that works in these industries that are affected, and ultimately your clients, they need their day in court. And so I think that's the biggest takeaway, is making sure that each of us really understands and figures out what ways we can make an impact for the betterment of our community right now.
Thank you, judges, for your service. Also, thank you for your time today. This has been just amazingly informative and helpful. And we look forward to coming back maybe a month or two from now and hearing about any updates or learning that has taken place. Thank you for your time.
Thank you.
Thank you.
Thanks.
We are now live with Mr. Bill Kroger and Judge Collier to take any questions and answer any.
Great, thank you. Thank you very much for being here. First, thank you for participating and listening to the webinar. There's been a bunch of questions that have been posted. Many of these have already been answered by the comments, which were very helpful. From some of the comments were from our own judiciary. Some of the comments were from lawyers. Let me just try to tick through as many of the questions, Judge, as I can, and at least get your feedback on some of these. First thing, how many participants can one of your Zoom hearings handle? There was a question about whether the courts have a pro version or a free version.
By default, we can have approximately 100 participants, but if there is a situation where a hearing would require more than 100, take it up with the court staff and we can make sure that we can accommodate however many we need to attend that hearing.
Why are the proceedings not allowed to be recorded? What was the thinking behind that?
There's several rules. Rule 226A of the Texas Rules of Civil Procedure, the local rules, Rule 5 of the Harris County Rules, Rule 12 of the 11th Administrative Judicial Region of Texas. So there's several rules that are already in place pre-pandemic that does not allow anybody to record an official court proceedings. It really comes down to there's an official court reporter that's sworn in and has specific duties to maintain court official documents and recordings. And so there can only be one court record, and that's based off of the official court reporter of that particular court.
If I'm preparing for a Zoom hearing in your court, do I send the exhibits to the court reporter in anticipation of that hearing? Do I file them with the court? How do I make sure the court has exhibits I need for the hearing?
So that's going to be dependent upon how you would like to keep your record. So if you would like for those exhibits to be a part of the clerk's record, you need to file that. If you want it to be a court record, a part of the court's record or the court reporter's record, you need to email the court reporter in advance the exhibits for that particular hearing.
Judge, one of the things I learned just from doing this presentation with you is, for example, the distance, like this is probably a much more comfortable distance looking at my image on screen than I did during the presentation because it was too close, but I was also looking at stuff on my computer. I know you have a few tips for Zoom hearings. We can make that another presentation, but can you give us just the highlights of some of the kind of big picture or most important points you have or advice you have for how to do an effective Zoom hearing?
So first and foremost is making sure that the court and the court reporter can hear you. So pay particular attention to the sound and pay particular attention to the mute button because it's your friend in Zoom hearings. It's particularly important when you're having private conversations, confidential conversations with your staff and the paralegal. So become very friendly with that mute button and use it often. Make sure that you don't use speakerphone or any fancy boardroom that your law firm may provide you, because oftentimes it sounds very distant for the court and the court reporter. And I think it's really good for the lawyers to understand that although you may be popping in and out in a very quick Zoom hearing that may be 5 minutes, the court has been in a hearing potentially all day. And so you have to really pack your patience and make sure that you have the necessary things on file. And it's important to just get in the habit of filing your proposed final judgment or your proposed order before your hearing. We are so used to having the ability to, you just reach over the bench and hand the court your proposed order at your in-person hearing. And it's going to be really good if we can just get in the habit of making sure that you file it before your hearing, because even when we come back into the court, you will unlikely be allowed to approach the bench. So it's good to just get in the habit of making sure that you file your proposed orders timely.
With regards to Zoom depositions, have parties objected to those, and how have the courts dealt with objections to those depositions? At one point in the presentation, there was discussion about a 360 webcam. There were questions about what is that, how does that work? What kind of advice do you have for Zoom depositions?
So first, look at the court's particular website to see if there's a standing order. Many of the civil district courts have a standing order with respect to remote depositions. And I want to say the vast majority, I'm not sure if all, the 113th definitely has a standing order in which a party may not quash or object to the fact that the deposition is being done remotely. So if that's your only objection to the deposition, is that the witness is being in a remote location for that particular deposition, that cannot be a basis to quash that deposition. So first, look at the court's website. Second, when we talk about credibility of the witnesses, when we talk about potential coaching of witnesses, I think it's really important that we remember how we practice and how the profession worked pre-pandemic, because that can be used post or during this pandemic. So and this happens often, and I'm sure you've always have also been in the situation when a witness seems as if they're relying on something other than their own memory, oftentimes the lawyer calls them out on it. Before this pandemic actually happened, I was in trial and a lawyer had a witness, and during the questioning, the witness was looking at their lawyer. And the lawyer just said, "Hey, why aren't you looking at me? You're looking at your lawyer." And so these type of ways, and I think Judge Hawkins was talking about the innovative ways that this bar usually comes up with creative solutions in making sure that if there is potential credibility issues, you say it on the record. Some of the great technology that's out there is the 360 cam. There's a couple of other things that you can have a view of the entire room. And so potentially a lawyer, if there's a credibility issue, if there's an issue that you anticipate, if you want to make sure that you get that necessary equipment to have that deposition, you can do that. And it may solve additional issues that may come
up. There was a question about how limiting the number of people in a courtroom is consistent with the constitutional requirement of open access. And related to that, does this mean in order to make the courts open to the public that all of the hearings and trials will also be videotaped or on Zoom so that the public can watch online? And lastly, related to all that, have there been any problems, for example, with trials or hearings being posted on the internet or getting used outside of the courtroom?
I'm not aware of any problems that have come up because of the open records requirement. All of our hearings and trials are live streamed in some way or fashion. Initially, folks went on YouTube and have pulled away from YouTube and have done the public access link that the Harris County District Courts have provided us. And I saw in one of the questions, they said, where can we find that? And where can we post that? Because that's one of the comments I had, is maybe give that link to your associates, law students, your clients. And what you want to do is you want to go to that particular court's website. So if you had a hearing in the 113th, you go to the 113th website and the public access link is right there. It tells you the cause number, what type of setting it is, and then the public access link. So once you click it, you will get to the court live stream, and that takes care of any open courts issue. For any trial that is happening, there will either be a live stream if the doors are locked to that particular courtroom to ensure court access, or the doors will be unlocked and members of the public can attend that hearing so long as that it does not exceed the capacity that's allowed by the fire marshal.
Let me just close with a couple of observations with regards to the questions that were posted. There were some comments about whether we could do something similar to this, specifically for the family courts, the criminal courts, and the probate courts, which I think would be an excellent idea, and we will try to do that. We'll also do some updates of this presentation as we get closer into August. The last idea I had, Your Honor, I thought we might just discuss it, is there were concerns about whether the people who would show up for jury service would be representative of the community while the pandemic is present, and that people might be worried about the safety measures that are taken. It might be that the bar and the courts could work together to provide information to the public through formats like this or through public television commercials, things like that, to make people aware that the courts are safe and that those measures are being taken. I wonder if you have a thought on that.
As Judge Hawkins mentioned, we've had a lot of discussions about this because the judiciary is concerned and wants to make sure that the call and the panels truly represent the community. And some of the ways that we've worked to kind of alleviate any potential issue is making sure that we provide information in the jury summons that allows the public some comfort, so that they recognize that we're putting in some safety protocols and procedures so that they feel more comfortable to participate. I previously in the pre-recording talked about a online registration in response to the jury summons. So the judges will be able to see the demographics of the folks that are registering in response to the jury summons. And so we'll pay very close attention to see whether or not there's some major irregularities or not, and hopefully not, because we are letting the public know that because we're taking these changes, because we're implementing some safety protocols, hopefully they feel confident enough in serving. And one of those is finding a larger space for jury assembly. And so for the folks that have served before, they will notice when they get the jury summons that we're telling them, hey, we don't want you to appear yet. We need you to register online or give the clerk a call and give some information before you appear online. And so I think some of these acts that we're taking now will help alleviate any issue with the right communities coming to serve for jury duty.
Thank you again for your time, and thank you for everybody participating in this. We look forward to getting back to you soon. Be safe and enjoy your week.
Thank you. Thanks for doing this.